He's with the firms of Park Zegler here in Virginia Beach, and he'll be talking to you today about technology and ethics in the legal practice. Thank you.
How y'all doing? Excited? Yeah, so I was told it's my 10th year anniversary from college today, and I'm literally about to head on the road and go back to Wake Forest. And I asked Ed, hey, can you give me an earlier spot? And he said, sure, I'll give you 1 to 3 right after lunch. And everyone's nice, energetic, full of energy. For the other 99% of you, the real coffee is the box furthest to the right. The one right next to it is decaf. If you make that mistake and I see you snoring, I'll leave you alone. So today what we're really here to talk about is what you can and cannot do with technology. So effectively and ethically, what can you do with all of these newfangled devices? And the slide, of course, is already dated. If anyone actually remembers what one of those are, I never even had one. Okay, so my boss actually helped me originally write this PowerPoint presentation and outline. Most of all the hypotheticals are mine. I picked the most flattering picture I could find, and oh, that's me and not my wife. Okay. So obviously technology changes. Technology is how we use nature and the laws of physics to help ourselves out. We've come a long way from sticks, flint, and fire, all the way up to smartphones, Bluetooth devices, portable mics. So first question, do we have to use technology in the practice of law? Any takers? You in the back making the glasses. Do we have to use technology in the practice of law?
Today, I say yes. We gotta be good at it.
Okay. Any other takers? Yes? I tend to agree with all of you. Both of these cases, Munster v. Gracchi and Griffin versus Maryland, certainly hold a lawyer to a standard of knowing what's out there. While there is not necessarily an explicit ethical duty, thou shalt use technology, I think it's implied at this point, probably. None of these are Virginia cases. However, I'm sure there is a Virginia case. You can see one of them, lawyer tried to serve someone, and this person you could find easily on Google. So that looks pretty poor if that happens to you in court. Also in Maryland, it is a matter of competence for lawyers to investigate social networking websites. So that seems to be sort of par for the course. The applicable, now there is an ABA model rule on the subject. Note that differs from the Virginia rule on the subject, but Model Rule 1.1, Comment 8 essentially gives you that duty to maintain the requisite knowledge and skill. Lawyers should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. There was a proposed change to our Rule 1.1 that basically adopted this rule. However, we're Virginia, and we proposed a new change. So this is the current proposed change to the rule, current as of February 28th of this year. Don't believe it's been adopted yet. However, if it has, I'm sure someone will correct me. Basically, it says attention should be paid to benefits and risks associated with the relevant technology. That's it. The first proposition would have added, including the benefits and risks associated with technology relevant to the lawyer's practice, onto a lawyer's duty to maintain the requisite knowledge and skill. So in other words, they took out this language from the duty and just put it in there. So this is the question, does the new proposition remove any hint of duty of technological competence? And quite frankly, the counter question is, do current civil procedural rules already mandate some degree of competence with technology? And the answer is, of course, there is at least a hint of a duty in there. In fact, service via fax on a party once you start a litigation is permissible as long as you do it before 5. Otherwise, it's the next business day. So technology has already been written into our rules of practice. Now, if you're in federal court, they have an e-filing system that you pretty much have to use. So I would say it is likely that one is inferred if not explicitly stated. Okay, now we're going to go through some of the forms of ways lawyers have used technology in the past. At the end of this, I'm going to ask if anyone knows of anything new, because new things keep coming out every day. So blogging was the first one that my boss included when he first wrote this outline. It's short for weblog. It's basically writing a journal on the internet. Don't really have to hammer away at this, but it looks like 4/5 of lawyers nowadays blog. So good way for cheap publicity, but there are some pitfalls to definitely avoid with blogging. There are a couple blogs to check out. I think I've checked out one of these once. Also Above the Law is a personal favorite article site of mine. One has that bent. Now on to social media, which if you practice family law is a great source of evidence. If you practice criminal law, it can also be a source of evidence. So what came first, at least in the slide, I did not include MySpace in the slide because it's changed quite a lot. But LinkedIn came first, founded around 2002. Basically, it's an online Rolodex. Does everyone in here know what LinkedIn is? Yes? Okay. Everyone in here know what Facebook is? I hope so. It's over 10 years old. I will leave this up there just for the sheer sake of the numbers. 1.41 billion active users. That's 4 times the population of the U.S. is on Facebook worldwide, and they're raking in 12.7 billion in 2014. So we should all know what Facebook is. Twitter. Everyone know what Twitter is? Yay. Okay. Although it looks like we have 300 million active users. So that's about just under the population of the U.S. is also on Twitter. Even I'm on Twitter. We all know what Pinterest is. You put photos on the internet, comment on them, share recipes. Okay. You can see post-lunch is starting to kick in. What's trending? We all know what Snapchat is. You send pictures, they supposedly disappear, although maybe they don't now. Thankfully, I did not get involved in that craze. There's also some pretty good ideas, though, in terms of what's trending. Chirp came into mind. It's location-based media. And actually, Avo had contacted my firm a little while ago and asked whether or not we wanted to be on some sort of internet priority list. And essentially, if someone searches on Avo within a 5-mile radius of your office, if you're on their list or whatnot, your name might come up before someone else's. So location-based advertising is certainly probably going to be a trend of the future. It's a lot more easy to get at people's locations now, especially if you have one of those smartphones on and haven't messed with the default settings. And just a couple other ones. Feed, apparently people will pay to follow social media now. Wish I'd have gotten on that bandwagon. So, ethics in social media. If there's one takeaway you take from this entire CLE session, the biggest takeaway would be this. Doesn't really matter now what medium of communication you use. The rules of ethics are still going to apply in full force. There's no special email exception. There's no special, Facebook exception. Obviously, you have to take into account what you're actually doing and what you're using. But if you're putting speech out there in a commercial context related to the law, all the rules of ethics are still going to apply. So the same rules of ethics would apply to you sending out someone a letter as they would an email, potentially as they would a post. And that's sort of what we're going to suss out over the term of this. But that's the one big takeaway is before you do anything on the internet that could possibly get you in trouble, check the rules of ethics. It's the biggest takeaway from this entire thing. Can't stress that enough. All right. So some rules we'll be discussing today. 1.1 is competence. 1.6 is confidentiality, which is huge with electronic communications. 1.18 is prospective clients. This becomes bigger if you have websites that solicit whether or not they want to hire you. Access to evidence is big, Rule 3.4a. Discovery compliance is also big, and it intermixes usually with 1.6. Jurors, obviously you don't want to be communicating with them before the trial. Ex parte communications with judges, if you're friends with the judge on Facebook. represented party communications, communicating with someone that has a lawyer, still counts if it's on Facebook or any other electronic media. Pretextual searching, advertising, it's another big rule, and staff. So anything that you can't do, you can't go out and tell your staff to do it for you. So here are some common ethical pitfalls that have happened in the past. If you comment on a pending trial to a juror online, or if you're a juror, if you sound off at a judge or other attorney online, some of you locally may remember there was a local case that had to do with a social media post. It involved a defamation lawsuit. So think it through before you put it online. Revealing privileged information. If you sound off about your favorite or least favorite client online, don't. Exposing yourself to defamation claims, sending what may appear to be legal advice, violating solicitation rules, anything you could have done with mass mailings, you can now do much quicker with the internet. You give out legal advice to your buddy who's in North Carolina, and you're not licensed there. You've probably practiced law where you're not licensed. This is becoming more of a concern. What happens if you click on the wrong link and your system gets hacked and all of your clients' personal information gets stolen? Happens to banks, happened to several big retailers. What do you do if it happens to you? And then, of course, all the other things that we talked about. So this is a fun real-life example. There's a judge out in Texas, Judge Chris, as far as 6 years ago, was speaking about this, so this is nothing new. Essentially, she'll Facebook friend the attorneys that practice in front of her. Not a bad idea, right? And this will, of course, give you an example of what happens when you don't think before you post. So there's a trial. Prosecutor asked for a continuance for a week to attend a funeral. Reasonable request. Who in here would not deny that request for a continuance if you were on the bench? Huh?
It depends. Whose funeral is it?
Fair enough. Judge granted the continuance. The prosecutor posted photos of himself drinking on social media. Could have been at a wake, but doesn't really matter. The judge confronted the prosecutor about it. The prosecutor asked for a second continuance later, and it was denied, and she defriended the judge. Second example is a prosecutor apparently posted a crime scene photo on Facebook. Do we have any prosecutors in the room, by the way? Prosecutors or former prosecutors? Any takers? Okay, so you and I are the only ones. What would happen in your office or correct me if I'm wrong, but most offices have standard confidentiality policy. You don't blast things out to the public.
Rarely comes out,
Exactly, because it's confidential. Prosecutor also posted comments from law enforcement about the crime on their Facebook profile. And this was Judge Chris's response. You aren't thinking one bit about the fact when you're asked to provide discovery to the other side, this is going to count. So if you're posting crime scene photos, law enforcement comments, and they're bad comments, they affect the credibility of the witness, Brady applies, doesn't it? And just as a secondary level of analysis, and this really applies to either side of the case if you're posting photos online. How do you think this would affect your credibility with the jury? The other lawyer has this information. Oh, this guy's guilty as sin. Well, guys, look what their own attorney posted on the internet. So obviously, no one's going to do that nowadays, but in the newer days of Facebook, people were posting everything, apparently. So a juror in Detroit posted on Facebook before a trial was over. They said it was going to be fun to tell the defendant they're guilty. Anyone have any problems with this? Defense attorney's son finds the post. Ultimately, the juror was fined $250 and had to write a 5-page essay. This is the kicker, though. Defense attorney asked for jail time for contempt of court. And even lawyers can go to jail for contempt of court. So serious stuff. You can break laws posting on the internet. Another example, public defender reveals client confidences relating to a pending matter in their blog. Anyone have a problem with this? So did the public defender's office. She was fired. She'd been working there for 19 years. She was also disciplined by the Illinois State Bar. So, big takeaway here is remember Rule 1.6, don't reveal information protected by the attorney-client privilege. That applies to the internet too, is the big takeaway from this. All right, so here's a question. What about researching a party opponent's social media profile? Has anyone in here gone on to a party opponent, a defendant in a criminal case, the victim in a prosecution case, or the other party in a family law case, the injured person in a civil case? Has anyone ever done it? Okay, so we have 3 people, 4, 5, 6, okay, only 6. Now, I'm doing the analysis backwards here, of course. Virginia Rule 8.4c prohibits dishonesty, fraud, deceit, or misrepresentation. So an underlying question is, can you friend a party opponent to get access to their profile on Facebook? Does anyone have a problem saying, no, you can't friend them if you're the party opponent? That would seem...
What was the question?
The question is, you're the attorney. Can you friend the party opponent on Facebook to get a look at the profile?
I think if they're represented, you're going to run afoul of communicating with representative parties.
That's one part of being correct. But also, and that's, I want to say, Rule 3.4 or 3.3. 4.2. You're absolutely right. If they're represented, you have a problem. Rule 8.4, though, also will probably apply to this. If you're friending a party opponent, you're saying, hey, let's be friends, you're engaging them in a pretext to reveal information. So if you're friending them, saying, hey, I'm suing you or I'm defending against you, I'm going to attack your credibility in the future, I don't think that you can friend them on Facebook. Also, you can't use an agent to go around the rules. And this is really more where this comes up. Haven't really seen too many examples of lawyer friending party opponent, mainly because of the rule you cite. You don't want to talk to them because they have a lawyer. But having your staff do it, big no-no. Because if your staff is doing it, oh, hey, let's be friends, your staff's really probably doing it to look at their Facebook profile. Yes? That's an interesting question. So if you're already friends with a party opponent, when your action starts, do you have to defriend them? Well,
You probably have a conflict anyways, so why would you represent them?
that would be my counter question is, can you really be, adverse to this party if you're their personal friend? Probably not. Interesting conundrum, though, if you found that out later, but
Question.
yes.
Before we move on.
Sure.
So what I'm hearing you say is, if someone's not represented, opposing party not represented by an attorney, I ask to friend him, say him, and he can accept it or not accept it,
True.
but are you stating that Rule 8.4c says that by me even saying I want to be his friend would be dishonest because I'm an adversary? Is that what I'm hearing?
Yes, and that is a potential argument that could be made, and actually, if you are following along in the outline, which I see everyone is doing, let me turn to the right page. I want to say okay. The Philadelphia Bar applied this indirectly. So through an agent, it's page 12 of the outline. But basically, they declared a lawyer's plan to collect information about an adverse litigation witness by hiring an investigator to access the witness's personal online social networking profiles to be unethical. They opined that the conduct would violate Pennsylvania Rules of Professional Conduct 8.4c, 4.1a, which is knowingly making false statements of material fact to a third person, and 8.4a. And the attorney was held accountable for the investigator's conduct. Yeah.
That's New York,
Huh?
that's New York.
It's Pennsylvania. One of the other 3 commonwealths in the country. And keep in mind, the Pennsylvania ethics opinion is not a Virginia ethics opinion. However, if it does apply the same rule to the same essential fact, you might run into problems here. So the safest course of action is obviously don't do it. But to answer your question with the question, if you're asking someone to be their friend and you're adverse to them, are you really trying to be their friend? Yes?
What if they ask to be your friend?
That's a great question. First layer of analysis, obviously, is do they have a lawyer? Because if you know they have a lawyer, you run into Rule 4.2, which Rob brought up. If they don't have a lawyer, and they're asking to be your friend, and you're suing them, the same question sort of applies. It's just a slightly different time frame. There's, to the best of my knowledge, there's no legal ethics opinion on this. There's been no disciplinary action on this that I know of here in Virginia. There has been up in Philadelphia, but that involved doing it through an agent. And that's also usually where you see this happening is someone sends their office assistant, their secretary, something of that nature to do it. And that also adds an extra layer of deception because you're using someone else that isn't you that appears to be innocuous. So I have more of a problem doing that than maybe the way you're doing it personally, but there's still a lot of pitfalls there. Yes?
Sorry. How does this play in for guardians ad litem? Because I've had it in family law situations where a guardian ad litem or her staff will contact my client or the other side through social media or monitor Facebook pages and things like that. Does that rub with this at all?
Which person's staff is contacting who? So are you?
Guardian ad litem staff
Okay.
will be contacting my client through social media. And I know we always will say you can contact my client directly, so the, Rule 2.2 or whatever you say wouldn't apply. But it is for the purpose of investigating for case-related stuff. Does that rub with Rule 8.4C?
Off the top of my head, can't give you a fully reasoned answer, but if we're thinking through this out loud, the GAL represents the children, is charged for representing the best interest of the kids. They're given pretty wide discretionary investigatory powers. The second question is, do they have the authorization to speak to them under 4.2? The third question is there some sort of other release that's been given? So if either client's already given another release, hey, I'm releasing this social media information for you to investigate, I don't see any problems. It does probably get a little trickier if there's no release at all. However, is it they're contacting them on social media or they're offering to be their friend? The first question that anyone would ask is, what's actually happening? So in the example, it's you're friending them to get access to their information. In this example, you're contacting them directly over Facebook, so it's or maybe another form of social media. So with Facebook, it's a fairly complex social media platform, so it's got a direct messaging feature. You don't have to be friends with someone to use that. In fact, the messaging is just like an email, and it's even treated like an email for the most part under the Stored Communications Act. So in terms of, if they're just contacting them over social media directly, you may not have as much of an issue, but it depends on what they're asking. And the second layer of analysis is, with the GAL, can they get at it anyways? And the answer is, yeah. They can send you requests for production of documents, requests for admissions, anything. They could send you things to get at it, and obviously it's probably going to hurt your case if you don't cooperate with them, but just contacting them directly if there's an authorization in place over a messaging feature, well, I don't think that's that much different than a phone call or the email, but it depends on what they're asking for.
What I'm thinking of is they'll go back and look at pictures. Is there drug paraphernalia in the back of this photograph? Or is this an underage person drinking at the home of so-and-so? That kind of investigative
But the question is this, what are they doing? Because this involves friending someone to then get access to their profile. If their profile is already public, which, how many people have had a client with a public Facebook profile? Like everyone in here, right? And you go through the profile and you find some really bad stuff on there, just doing it yourself. And I did that to a lot of my clients. The first thing I do is I check and I see, can I find them on Facebook? If I can, you know, maybe talking to them about privacy settings. Because another thing to remember about Facebook and other social media, you are putting this out into the public. So what a Facebook used to be is that book we all got at the beginning of law school that had everyone's picture and their class year. That's a Facebook. And this particular social media site stole that and put it online. So if you were in a Facebook, you were publicizing information about yourself already. So they published this. If it's publicly accessible already, I don't have as much of a problem with it. Like you can investigate and should investigate people on social media, but you can't do it beyond a search that doesn't disturb them. So, and I want to say that's also in the outline regarding looking at their LinkedIn profile, that you can see when someone checks your LinkedIn if they have a profile as well. But with Facebook, you can't. So it truly depends on what the GAL is doing. If they're just messaging them, probably not that bad if they have an authorization to contact them directly. And if they're snooping through their profile that's public, I don't see that much of a problem with that either. Now, if they're asking for more information under a pretext, that's when you start getting into these rules. Yes?
I think that's really the rub. Everybody knows the GAL is looking for everything possible. There's no pretext. We call it a friendly request. They're not actually literally asking for friends. And so it's understood at the very beginning. They want access to the information for the sole purpose of what they were doing in that case. That's why there's no pretext for dishonesty or fraud. You know that's what the GAL is looking for, and that's what you consent to when you get that authorization to contact.
But I would ask this question though, is, you know, when did this happen in the case? Like, have you already had the authorization form signed, or is it before that? Because I think that would matter. We do know the GAL is investigating, but as a GAL investigator, you also have the power to issue discovery. And you can get a lot more information on someone's Facebook by discovery than just snooping their profile. You can get their messages, you can get a whole slew of things. So the timing is everything, what they're doing is everything. It's a very fact-intensive question. Any other questions, comments, concerns? Other social media hypotheticals? Or have we, yeah, last question, can you look at their public profile? Absolutely. They published it. They don't have any Fourth Amendment rights to it. They don't have any expectation of privacy to it because you put it out in the public. It's probably Google searchable. And it's the same, yes?
I'm just curious, is this a similar analysis to dealing with jurors or potential jurors, or is there a different analysis in that context?
I think the question becomes, what are you trying to do?
I guess trying to look at public information, and I might be misremembering this, but I think there's been some case laws and ethics opinions come down that say that anything public for potential jurors is basically fair game to try and uncover any hidden bias or any slant that might result in an improper decision being made back in the jury. But trying to friend them, trying to gain access to additional information beyond that, you run into some of the same issues.
I think you just hit the nail on the head. Is it public or is it not public? So with the jury, you have a different set of rules that apply. You can't talk to them at all before the proceeding, during the proceeding. You can pull them after the proceeding. So if it's public, you could find it out anyways. You're right, I don't think you have any problem. But you can't issue discovery to a juror. And that's what voir dire is for. And you can't really do too much more digging. If it's not public, then you're kind of out of luck. Any other? Yes. Yes. The answer to your question in part would depend on what you're trying to do, because part of this obviously depends on who's the other party. Is this a witness? Is this a juror? Because there's a lot more protective rules with jurors versus witnesses versus parties. And for the second layer of analysis, at least with a juror, where your rules are more restrictive, most restrictive on whether or not you communicate with them. On Facebook, you can choose who you publish your information to. And Facebook does have a pretty lengthy terms and conditions pages, for lack of a better word. I mean, they have a very comprehensive user statement. They tell you what they're going to do with your data. They tell you who can access what kind of information. So if you're only choosing, for example, with your wall feature to post to your friends, then that's the only party that you're choosing to publish your information to. Now, if your friends share it, obviously you can't control that. But just a first layer analysis, you're only choosing to publish it to a select group of people. So with your juror example, if it's not just out and out to the public, you're probably out of luck. And even if you're not on its face, what's the safest thing to do if you're not sure? Call the ethics hotline. But that aside, don't do it. If you're not sure, if it doesn't feel quite right, don't do it. Now, if it's a party or a witness and you have discovery powers, you probably don't need to worry about this stuff. You can just RFPD them or request for admissions. If you're in a criminal case, different layer of analysis applies. Law enforcement can subpoena Facebook, but they've got to meet the probable cause standard looking for information. So you can't just go fishing through someone's profile, and that's probably where there's a big difference between civil and criminal with Facebook or other social media. Any other questions? Okay. Here's a question. Can you post how you feel about a judge or other judicial officer online? Come on, someone answer this.
Freedom of speech. Yes.
Read Rule 8.2. The First Amendment does actually come up in some of the cases we're going to talk about, though. So that is a legitimate thing to have in your mind. Let me give you some bad examples first. Sean Conway blogged about a judge being an evil, unfair witch, and the Florida bar then disciplined Conway for his remarks, and the Supreme Court held that the First Amendment did not protect his remarks. So our Rule 8.2 has to do with making statements about a judicial officer or someone's fitness to practice law with reckless disregard for the truth. So if you're just name-calling a judge, probably a really bad idea. There was a case in, where was the case? Michigan, yes. The attorney called the judge, well, I'll let you read what he called them. And I am substituting the French word for what he asked them to kiss. Michigan bar didn't find that too funny. But can you post comments, read Rule 8.2 before you do anything? You go back to the first takeaway of this presentation. Can you do it? Ask the rules of ethics first. So these rules have to do with advertising and ethics. 7.2, it says it's deleted. It actually got moved into 7.3 and 7.1. I have no idea why. Fields of practice, certification, firm names, and letterheads, all of these rules are going to come into play in terms of advertising on the internet. So they're rewritten in 2013. They're medium neutral. They apply to every bit of communication that you can do. Pretty straightforward, right? Rule 7.1 deals with communications about your services. 7.3 deals with direct contact with potential clients. 7.4 deals with fields of practice and certifications. And this deals with law firm names, letterheads, addresses, who's in your firm, where are they licensed, where are you located, things like that. Everyone's probably asking, why do we care about where we're located? Because some people have virtual offices, but we'll get to that in a few minutes. Okay, who in here, of the people in here who are in private practice, who in here has a website? Everyone's kind of, maybe I have a website. Okay, so a lot of people in here have websites. On their websites, does anyone have a client testimonials feature where you publish your case results? You've got one, sort of. Okay. Got it. Does anyone have any place advertising case results? No one? Okay, we have one. 7.1b applies to these. So basically you have to have a disclaimer, and if anyone in here has ever gone to a bank or a financial planner, this disclaimer will be really familiar. But before your disclaimer, the first thing you have to do is you got to put the case in context. You have to make sure that A, people know what happened, and B, people know why this is an important result. So for example, if you're posting, got my client a first offender on a possession of alcohol charge, you can make that sound really special, but if it's sort of the standard practice in your jurisdiction for someone with a first offense to get that, you're probably going to have to put that online. So this got him a first offender becomes got him the going rate. So I'm using a very simplified example of how you can put results in context, but obviously you have to do that so that it's not potentially misleading. And the standard is that, is this actively misleading? It's potentially misleading. You've also got to give the financial services disclaimer. You have to state the case results depend upon a variety of factors unique to each case, and state that past performance doesn't guarantee future results. This is big, because you have to have this if you have case results. You've got to have this disclaimer, and you've got to have enough to put it in context. Those are two really big things that you don't want to run afoul of. Why do you not want to run afoul of these? There has been a case on this. I want to say it's a 2013 case. A criminal defense lawyer blogged about his past victories on his firm's website. The post actually included names, evidence, and charges against these guys. So he's putting his clients' names, evidence against him, charges against him out there. And before we discuss this, does anyone have any problem with posting your clients' names, evidence, charges against them, information? Yes?
Yeah, I've got a problem with that. I know it's public information, but by creating a new form for it, you're putting potentially embarrassing information and making it more accessible that can give your client that can feel bad.
The bar agreed with you. That very analysis comes up in Hunter. Does anyone not have a problem putting publicly discussed court information on the internet? Assume you haven't talked to the client. I mean, if the client's okay with it, then you've gotten their consent. There is no problem. But assume you haven't talked to them about it and you're just putting this out there. Where's our First Amendment person? Got it. Okay. Well, the Supreme Court of Virginia held that former Rule 7.2A3 was constitutional as applied to the blog and was properly regulated speech. Okay. However, held Rule 1.6, your confidentiality argument, was unconstitutional as applied to the blog, and a lawyer can post information previously disclosed in a public courtroom in a, and this is important, closed case. So obviously your case can't be pending. But basically in this case you had really two charges against the lawyer involved. And I'll get into the analysis a little bit deeper. If you've read the outline or you've even gone so far as to read the case, some of this will be familiar to you. But in essence, the lawyer, the first factor the court really latched onto, the lawyer only posted his victories. Didn't post any of his losses, just his wins. Second, it was on his firm's website. So this isn't his personal blog. He's not publishing it anonymously. It's his firm's website, sort of in the context of, look at my wins, look at my wins. Why is this important? Because First Amendment speech, you have personal speech and you have commercial speech. And the court applied a commercial speech analysis to his blog because it was on his website. And it only posted victories. Once you have the commercial speech analysis, you have a lot more ability to regulate that, and the court basically said, this is commercial speech, you're posting case results, you need this disclaimer, and you need to put everything into context. The flip side of it is this, it held it was unconstitutional. You have a public courtroom. If it's a circuit court case, we all know that a record has to be kept. So all of this information is out in the public, in theory, out in the public domain, and the court didn't have a problem with that. Keep in mind, I want to say in this case, some of his clients were also peeved against him. So he didn't talk to the clients at all. This information was out there, but it's confined to what was previously discussed in a public courtroom in a case that's closed. Now, is this a good business practice? I'm not a business lawyer, but in terms of your free speech, it does actually apply if it happened in open court. So, we're going to talk about endorsements. So, on Facebook, you can get likes. On LinkedIn, you can be endorsed for your skills. And question comes up, do the rules of ethics apply to these? And the answer is yes. 7.1 and 7.3 probably apply. These are going to be recommendations. So another important caveat to remember, if you're posting stuff on social media, LinkedIn is the one I would be slightly more concerned about than this. You're adopting the statements of others when you post on your social media site. So for example, I endorse Ed for trial skills. I'm actually making a representation. I've seen him. I believe he has good trial skills. So you probably shouldn't do these willy-nilly. And he is adopting my representation by putting it on his website. Hey, Alex endorses me. He says I'm a good trial lawyer. So if your client, for example, were to post, hey, Rob is the best criminal defense attorney in Virginia Beach, and Rob posts this on his LinkedIn, do we have problems with this? But can you advertise yourself as the best? Because when you, and the analysis is this. I know my boss would say he has problems with it, so I'm going to default to what Killam says. Okay, this is direct solicitation. So, first question is, what is a solicitation? It's a targeted communication started by the lawyer directed to a specific potential client. So this isn't just, hey, I'm putting up Park Ziegler PLLC on my Facebook page. This is, I am sending out an email to you saying, hey, do you want a divorce lawyer? So, and the next question is, could you do that with a letter? Could you do that in person? Can you do that with a phone call? If not, you probably can't do it electronically either. So, same rules apply. And we're going to come back to some of these fact patterns and the hypotheticals. So, yes?
You ever got a speeding ticket in Emporia, and you end up with like 20 letters in the mail, Emporia criminal lawyers. There's no prescription.
Off the top of my head, I don't. I'd have to have the rule in front of me. I know the same thing happens in several other counties in Southwest Virginia, and I frankly don't know how they get the names or any of that, but I've been fortunate enough not to get a speeding ticket going through Emporia.
You're driving around Wakefield, be careful.
Yeah, no, I've heard. I've been warned many a time. Okay, send it to me. So, what's cloud? The first question is, what is cloud computing? How many people in here are on a paperless or semi-paperless office? Show of hands. We've got a couple of fingers raising, some hands. Okay, I'm not the only one then. Of those of you who are on a paperless office, how many people, what's your setup? Do you have it all on site, or have you truly sent it to the cloud? How many people have it on a firm server, a firm drive? Just show of hands. Most of the people are paperless. And actually, by Monday, we will be totally cloud-based. So there is a difference, obviously, with having it on your own server versus the cloud, but all the cloud is aside from the guy taking up your after lunch hour, is a remote server. It's a server, so your most common form of cloud-based computing is going to be SharePoint, which is what Microsoft runs. There are a few other cloud services, and there's cloud-based practice management software as well. But it just means it's web-based, you have to be online to access it, and it is a remote server. So you have some of these companies building huge server farms out in the middle of the Nevada desert. That's the cloud. So we have some legal ethics opinions on this. 1872, basically you have to use reasonable care to protect client confidences under Rule 1.6. What does this mean in the context of paperless offices or cloud computing? You've got to exercise reasonable care in the selection. Well, let me ask you, now that I've put the answer up, what's reasonable care with protecting client information with cloud-based computing, or with just electronic practice in general? What do you have to do? Yes?
One of the things that I did when my firm started using cloud services, I actually read through the terms and conditions and had a conversation with the dedicated representative that we were working with for the cloud storage, just to communicate what our concerns were and see what they did in terms of security research, if there was any additional options we could purchase, things like that.
Okay, so step one, read the fine print. You have to read the user statements. What are they going to do with your information when they have it? Is it truly confidential, or are they going to sell it to advertisers so you can be advertised to? Because your first and foremost goal here is to protect client confidences. So if you're using a cloud drive that isn't 100% confidential, that's bad. So exercise care in the selection of the vendor. Obviously you don't want to use a fly-by-night company, or you may not want to use your own setup unless you know what you're doing. But you have to have a reasonable expectation the vendor will keep the data confidential and not accessible to others. So in terms of that, what else are you looking for? What would lead you to have this expectation that your information is private? Yes?
I think at a basic level, you have to make sure that you're accessing the internet and cloud securely, and not allowing unauthorized access to that information.
Okay. What goes into that?
Well, I mean, obviously locking down your Wi-Fi, some sort of reasonable password protection, not using publicly available Wi-Fi for any type of work at all. Make sure that the program, if it's a Dropbox, you're not automatically syncing over a public Wi-Fi or something like that.
What else? Someone else? Do you encrypt your data? That was more of a rhetorical question, but I pointed it at you because you have had experience in an organization that does use encryption with their communications. So obviously you want to lock off your access points. So at the storage site, you don't want anyone who's not supposed to be snooping to be snooping. At your access point, you don't want anyone else getting in. That's still point A to point B. So you have C, which is the line between the two. The line between where you are and the cloud needs to be secure. So encryption is a possible method. In theory, you can just limit access at point A and point B and you're fine. But a lot of the cloud providers will tell you up front, for example, Clio, we have 256-bit encryption of our data. So that's something else to consider. Or if you're streaming over Verizon's data stream, are they secure? Because it's not just your access point and the other access point that you're worried about. You are actually supposed to be accounting for, I hate to use the term wiretapping, but you don't want someone to dip their finger in your data stream, like a wiretap. So, yes?
Something else that I think would be important for firms to consider with this is, does your cloud company have a means of decrypting that information? Even if it's stored securely and it's encrypted on their server, do they have the key to unlock that, and are they going to do that? It goes back to reading the fine print. Are they going to do that in response to a subpoena or something like that?
And these are all questions that you should ask at the front end. And this is what the rule requires. So if you're actually going to, go forth and be paperless, which is great, by the way, you need to have a long upfront sit-down session with your data provider. Hey, my data is encrypted. Are you going to snoop it? If you're going to snoop it, why are you going to snoop it? Does the fact that we're a law firm, we have confidentiality, mean anything to you? Okay, so does anyone in here deal with having a virtual law office? Like satellite site or office sharing or anything like that? Okay. Yeah, and keep in mind, I know a few people I used to practice with who do the same thing. They have office sharing, most of their stuff is on the cloud, and they'll meet with the client in a group office conference room. So obviously you see this more with smaller firms than maybe the enormous firms, but this is a wave of the future, and it certainly helps keep down overhead if you're worried about paying for an office. So a virtual law office defined by the rules of ethics, the practice where legal services are provided online and accessible anywhere. So in other words, my firm has a virtual law office component with our practice management software, Clio. Our clients can access their file 24 hours a day, 7 days a week, if they have their logon credentials. That's a form of virtual law office. It can be part of brick and mortar firm. So we have a physical office, we have Clio, or it can be an entirely online enterprise. So there are a couple of legal ethics opinions that apply to this. 1791 basically says, and these are sort of set up legal ethics opinions to, you can have a virtual law office. 1791 says, you don't have to meet with your clients in person. You still have a duty of communication. You still have to convey to them everything that they need to hear, but you don't have to sit down and have a face-to-face. Ethics Opinion 1818 says one can operate a paperless office, storing and providing client files in electronic form only. There's a caveat, and that's provided that they consent. In 1872, addresses cloud computing and executive office suites, and says a non-exclusive office space or virtual office that's advertised as the location of the firm must be an office where the lawyer provides legal services. So whether or not you provide legal services at this place, you're going to have to do this analysis. So how often do you use this physical space? Is this an office you use once every 2 months in the second state you're licensed in, or is this your go-to conference room? And do non-lawyers use this space? So is this your conference room and 2 other lawyers? Is this your conference room that you rent out from Goliath National Bank? How is this space used? And then 3, do you have signage? I would also go so far to state, do you have internet signage? So are you posting online, this is our office? But does it indicate that the office is a law office? So we've got some potential changes to Rule 1.6 as well, and they've been pending for quite a while. There's a proposed additional Section D of the rule. It says the lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information protected under this rule. So basically, don't broadcast client confidences over the internet. Okay, last year, when we covered this, there was a proposed comment 19, and now there's a 19 and a 19A. Instead of posting all of them up here, the takeaway is your cloud computing has to be reasonably secure. So what goes into cloud computing being reasonably secure that we haven't already discussed? Takers. No takers? Okay. Obviously, you want to limit your access points. Make sure it's only you or your agents or the authorized members of your firm that are accessing the data. Make sure that your vendor isn't going to snoop all your data when you're not looking. Make sure someone can't intercept the communications from where you access it to where the cloud is being stored. And some of this also will have to do with authorized users in your office. So if you have an attorney, for example, who has an individual conflict of interest that doesn't impute to the firm, do you have to take any additional precautions to keep them from accessing a certain file if they're available? Obviously, yes. And depending on how your system is set up, you can usually password protect the file and block it from a certain user. At least that's how we usually effectuate it in our office. The old school way is just putting a don't touch on the file, but we're a little more advanced than that. Okay. This was the proposed change to comment 19 last year. Someone can read that word for word, please. I'm kidding. Okay, this is the proposed, these are the proposed changes now. So it was one massive word sandwich and now it's two. And you can look at that in your outline. Essentially what they did is they removed two sentences requiring you to discuss certain things with the client. So these are some questions you want to ask in terms of selecting a provider, and this is, I forget where this is, but this is out west. This is a big server farm that they're building. So this is the cloud. It doesn't look very cloudy. Okay, first question, where are users? So if you're going to do cloud computing, obviously the first question you want to ask, where are the people who are going to be using this information? Is it just you? Is it you and your clients accessing it remotely? Where is everyone going to be? And to back up more, are your end users, your clients, going to be able to do this mobily? Or are they just going to be able to do it on a hardwired connection at home? These are all things you have to consider. So Clio, for example, your users, the attorneys, can use it on their phone. You can set your firm calendar up on your phone, set appointments, do everything through a smartphone. So these are all things that you want to know before you sign them online. Second, where's the data stored? My boss knows where the Clio farm is. But where is your data farm? Where is it processed? Where is it stored? 3, suppose you have an earthquake in California, which is where your data farm is. Does your company have a backup site? That's pretty important. Number 4, where's your support based? Is it only phone based? Will they come to your office? Will the tech support have access to your confidential data? Hopefully not. And then will subcontractors or outside personnel have access? Let's say your company is building a new data farm. You're going to want to make sure that their construction workers or their IT guys don't have access to your stuff. And you want to do this all up front. So the big takeaway is read the fine print. If this isn't in the fine print, ask the questions. So more questions. Does the customer have the right to approve in advance the transfer of data? Can a company move your information from one data farm to the other without asking you first? That's an important question. Riveting, but important. Who can access the data? Would be different access levels, tiered access. Who's going to supervise all of it? Are there monitoring and auditing policies and procedures in case you have a breach? So let's say you get hacked. What happens?